Good evening to the aspirants of the JCJ 2022 and whose screening test is going to be held on 13th August. And for that, I would like to say that you have to work hard and see that a good name should be bring to us. And I'm sure that everybody would qualify in the screening test. It is my hope. Okay, now read what I posted on the screen. Participants. Ananta Lakshmi. Ananta Lakshmi, mute and read what I posted on the screen. Okay, Sharad Babu, read.
Okay, sir. Good evening, namaskar. Welcome to the aspirants of JCJ 2022, JCJ 2022 Telangana State, MSH, KC, KSB, MSV. These are the hosts. And
see that now the key is a different place and this is a different place. I don't know, suppose if it is a right or wrong, somebody has to help to see the key. Could you keep the key on your screen or adjustant?
Sir, I am unable.
Because I told the same problem is there for me, because whether it is a right or wrong, again you have to make it out and see the key. Okay, for my questions, I do have my key. Okay, let me exhaust my questions. Let me exhaust my questions. Read.
Okay, sir. Okay.
First question, read.
Charge sheet under dash of the Code of Criminal Procedure 1973 charges have been framed in Section 170, Option B, Section 171, Option C, Section 172, Option D, Section 173.
Option D, 173.
Yes, it is the correct answer.
Option D, Section 173 is the correct answer. And the second question is, this appeal arises from an order dated 2nd March 2022 of a single judge of the High Court of Delhi in bail application number 196 of 2022 was decided in the case of Dash A. Veerrazu Kokiligada versus the state of AP, B. Kumari Hema Mishra versus state of UP and others, C. Mamata and another the state of New NCT, that is Delhi, NCT of Delhi and another, D. Only A and B are true. NCT means National Capital Territory of Delhi.
Option A.
WRONG.
Option A.
Option D.
Option D.
WRONG.
Option C.
Option C.
It is Mamata and others versus state of NCT of Delhi and others. And it is decided over there in that case now. Regarding the bail is concerned. Do you know that actually the daughter was kidnapped in this one? And on behalf of the daughter, father has filed a case. And for that case, they have given the bail in the High Court of Delhi. And he approached the Supreme Court, and Supreme Court say bail will be cancelled and he will be surrendered over there. That is the case law actually. Okay. Third question.
Now the third question is, the writ petition has been filed in the Supreme Court under Article 32 of the Constitution by a minor through her father for the issuance of a writ of habeas corpus or directions like nature for the protection of his daughter who has been kidnapped was observed in the case of Dash. Option A, B, Premanand versus Mohan Paikal. Option B, Mrs. Hiralal Ratanlal versus state of UP and another. Option C, Govindral Saganlal Patel versus Agricultural Produce Market Committee, Godhra and others.
Yeah, it is similar to the earlier case law.
And option D is also there, Lal Kumar versus state of UP.
In the very landmark case
Option
law,
D.
especially,
Option D.
yes, it's a very landmark case law, especially for the bail. And the right answer is option D is the right answer. That is the Lalit Kumari versus
Option D,
state of
Lalit
UP.
Kumari versus state of UP is the right answer for this question. And next question is fourth question. State of West Bengal, Uttar Pradesh, Rajasthan and Madhya Pradesh contended that the registration of FIR is mandatory dash of the CRPC if the information discloses a cognizable offense and no preliminary inquiry is allowed in such situation. A under section 151, B under section 152, C under section 153, D under section 154.
Option D. Under section 154.
Right. Option D.
So it is the right answer. Option D is the right answer under section 154. No preliminary inquiry is allowed. And fifth question is the rule of purposive interpretation has been preferred over dash in Chairman Board of Mining Examination and Chief Inspector of Mines and another versus Ramji. Option A, golden interpretation. Option B, mischievous interpretation. Option C, literal interpretation. Option D, purposive interpretation.
Shoot.
Option D. Option D.
WRONG.
Option B.
Option A.
WRONG.
Option C. Literal
It
interpretation.
is a literal interpretation.
Yes, yes.
Or we can say grammatical interpretation
As
also.
per meaning, sir. As per
Yeah. Meaning is concerned. The exact meaning, because when there is not obvious, the correct meaning should be taken. Suppose if it leads to the mischief, then golden rule should be applied over there. Suppose it also make it not a proper way, and then the mischief rule should be applied over there. And overall, it is not covered over there, then the purposive approach should be used over there. It comes in the interpretation of the statutes.
yes.
Yes.
Sixth
Sixth question.
question. This indicates that the only condition which is sine qua non for recording an FIR is in this regard, reliance was placed on option A, Lalan Chowdhury versus State of Bihar. Option B, Kanubai, Shamjibai, Dayanand versus State of Gujarat and four others. Option C, Potula Krishna versus State of Andhra Pradesh. Option D, Salamani versus Sub Inspector of Police.
Option A, Lalan Chowdhury versus State of
A.
Bihar.
Yes, it is right. Can you tell me the technique? What technique that you used it? Just sixth sense? I asked the question. Sir, it is confidential.
Somewhere, sir. Heard somewhere.
Okay, right. Seventh question.
Sine qua non means which is indispensable, compulsory, which is a must.
Okay.
The meaning of sine qua non. Third question. In that it was held that the registration of FIR must be done in FIR book or register as general diary contains only the substance of each FIR being registered at the police station. Option A, Dr. Rajni Alriwala versus Dr. D. Mohan and another. Option B, R.P. Singla versus C.K. Kapoor and others. Option C, Sri Satish Chand Saxena versus Sri Naveen Kumar Saxena and another. Option D, scroll up, sir.
Yeah.
Option C, Satish Chandra Saxena versus Naveen Kumar Saxena.
So option D, Madhubala versus Suresh Kumar.
Option C.
I think option C is the right answer for this one. To minorities also.
Option
Yes, option C is the right answer, Sri Satish Chand Saxena
But
versus
anyway,
Sri
that I will
Naveen
check it.
Kumar
I will check it
Saxena.
again. Okay, I will check it again later. Okay. Now go to the eighth.
Now the eighth question is, it is also noted that in view of dash of the Constitution, if there is any inconsistency between the laws made by the Parliament Code of Criminal Procedure 1973 and the laws made by the state legislature, the Police Act 1861, the dash will prevail. Option A, Article 254 and former. Option B, Article 254, 1 and later. Option C, Article 254 and later. Option D, Article 254, 1 and former.
option B, Article 254, 1 and latter.
WRONG.
Sir, option A. Option A.
WRONG.
Option D, sir.
Option
254,
D is
1
the
and
D.
former.
Option D.
Option D is the right answer. Article 254 plus 1
Section.
and
Class
farmer is the right answer. Because Criminal Procedure 1973 is the farmer one. And the state legislature, the Police Act is the state act. So, Criminal Procedure is the central act. And the Police Act is the state act. So, when the conflict comes over there, which will prevail?
The Criminal Procedure Code will prevail over the
That means
state
central act
legislature.
will prevail.
Yes, yes.
Because here it is written Central Act or Criminal Procedure Code. Suppose if it is not there, any other code is there which is made by the central government. At that time, the answer is the central government act will prevail over the state government act. That is the formula.
It happens in almost all cases.
Yes.
When the
Ninth question.
conflict arises, the central side prevails.
Yes.
Ninth question. In dash, that no arrest can be made on a mere allegation of commission of an offense against a person. Also, police officer can be tried and punished under section 166 for misusing his power of arrest. Therefore, section 154 of the code is not in violation of dash the constitution. Option A. Prakash Bhai Kanalal Soni versus State of Gujarat and 2 and Article 21. Option B, AB Venkateswara versus the State of Andhra Pradesh, Article 14. Option C, KM Hema Mishra versus State of UP and Article 14. Option D, Jogendra Kumar versus State of UP and Article 21.
Option D, sir.
Option D.
Right.
Jogendra
Option
Kumar
D.
versus.
Option D, Jogendra Kumar versus State of UP and Article 21.
Yes.
Now, 10th question is, cases in which preliminary inquiry may be made before the registration of FIR. Option A, matrimonial disputes. Option B, family disputes. Option C, commercial offenses. D, all of the above.
All of the above.
All of the above.
Actually, I would like to twist it, but later on that I found, even myself also did not know. Can we say the commercial offenses into the business offenses? So that's why I could make the all of the above. Otherwise, I would have to write there the business offenses. Of course, there is no word business offenses were there in that act. That's why that will be the right answer. But here I said, okay, let me write the all of the above. But rest of the other disputes also comes over there. Like in medical negligence cases, FIR cannot be made unless a preliminary inquiry will be done. And the corruption cases, yes, FIR cannot be registered unless the preliminary inquiry is done. So cases where there is a abnormal delay in initiating the criminal prosecution, these are only illustrative or not exhaustive list. So where the preliminary inquiry is done, then only the case will be registered. FIR will be registered. Okay, next, 11th question.
11th question is, delivery of possession. The formalities laid down for gifts under dash Transfer of Property Act 1882 are not applicable to Muslim gifts. A. Section 120, B. Section 121, option C. Section 122, option D. Section 123.
B option. Option 121.
WRONG.
Option
Option
D, sir.
D. 123.
The right answer is
123.
D, section 123.
Yes.
Yes, option D is the right answer. 12th question. As of now, homosexuality is legal in India and dash of the Indian Penal Code. 1860 has been abolished to a certain extent. Option A, section 375. Option B, section 376. Option C, section 377. Option D, section 378.
Option
Option
C.
C.
377.
Right.
367.
Option C.
Option
Option C, section 377 is the right answer. As of now, homosexuality is legal in India, but that has been abolished. That is in IPC 377. 13th question. Vishaka and others versus state of Rajasthan was a 1997 Indian Supreme Court case where various women's groups led by Dash are organization. A. Dina Kapoor. B. Naina Kapoor. C. Naina Kapoor. Scroll up, sir. Option D.
No.
Nina
Yeah.
Kapoor.
Option C.
WRONG.
C.
Nina
Nine.
Kapur.
C.
Wrong.
Option D, Nina Kapoor.
WRONG. The right answer is B, Naina Kapoor.
Option-
Naina.
Option B.
Yes, I told you no. The right answer is B,
Okay.
Naina. Naina Kapoor. Kapur Kapoor. Naina Kapoor. She has filed the case. Okay, next.
Realize the difference in Kapoor spelling. Okay.
Yeah.
14th question. Sakshi filed public interest litigation against the state of Rajasthan and the central government of India to enforce the fundamental rights of working women under dash of the Constitution of India. Option A, Articles 13, 19, and 21. Option B, Articles 14, 19, and 20. Option C, Articles 14, 19, and 21. Option D, Articles 14, 19, and 22.
Srividya, you can participate in it. It is me
Yes,
who
sir.
is doing
Option
this
C.
one.
Option C.
Option A.
Option C,
C.
Article 14, 19, 21.
Option C is the right answer.
I think option C is the right answer. 14, 19, and 21. 15th question. The petition was filed after Dash, a social worker in Rajasthan, was brutally gang raped for stopping a dash. Option A, Banwari Lal
Banwari Devi.
and second Banwari Devi was and second marriage. Banwar Devi and child marriage. C. Banwari Devi and second marriage. Option D. Banwari Devi and child marriage.
Option A. Banwari Devi's second marriage.
WRONG.
Option D.
Option D.
WRONG.
Option D. Option D. B. Banwar Devi and child marriage. B.
Are you sure?
Option C.
Option B.
Yes, yes, sure.
B.
B.
Which one?
Marriage. Okay.
Which one is sure?
B. Option
Option B,
I think
Banwar Devi. and
Option B is the right answer. BHANWERI, Banwari Devi, and it's a
Banwar
child
Devi.
marriage. It's not a
Banwar
second
Devi and
marriage.
child marriage. Banwar Devi and child marriage. Option B is the right answer. 16%. The chairman, railway board, and others versus Mrs. Chandrama Das and others on 28 January 2000. And in that case, who is or was the victim's name? Option A, Srimati Hanifa Khatun. Option B, Srimati Anufa Khatun. Option C, Srimati Anufa Bibi. Option D, Srimati Hanifa Bibi.
Option C.
WRONG.
Option B, sir.
Right.
Option A.
Option B is right.
Option B is the
Anufa.
option B is the right answer. Srimati Hanufa Khatun. That is
Khatton.
the right answer. Yes. I think, sir, she is the Bangladesh
Bangladesh.
lady. Yeah. 17th question is polyandry is prevalent in parts of North India by dash in the Jaunsar Bawar region. Option A, Pahadis. Option B, Paharis. Option C, Paharsis. Option D, Pahiris.
Option A. Pahadis.
WRONG.
Option B, sir. Paharis.
WRONG.
Option C.
WRONG.
Option D,
Option D.
Then
Paharis.
option D is the right answer.
Read the feedback.
Pahiris.
B, D,
Pahiris.
mostly.
Read the
While
feedback.
in our Himachal, a minority of the people justify and practice polyandry as descendants of Panchapandavas, 5 brothers who were husbands to a woman named Draupadi, daughter of King Panchala. They believe they have to carry on the tradition. Besides them, the Thoda tribe of Nilgiris, Najan Velala of Travancore, and some Nair caste systems in South India also practice polyandry. Polyandry means having many husbands. Now, 18th question is a marriage may be solemnized between two Hindus if the following conditions are fulfilled, but one of them is not a valid condition. Option A, neither party has a spouse living at the time of the marriage. Option B, at the time of the marriage, neither party is incapable of giving a valid consent to it in consequence of soundness of mind. Option C, has been subject to recurrent attacks of insanity or epilepsy. Option D, the parties are not within the degrees of prohibited relationships unless the custom or uses governing each of them permits of a marriage between the two.
Option C.
WRONG.
Option B, sir.
I said it's yes. Why it is yes?
Incapable of giving a
Because,
valid consent.
because in the state of unsoundness of
Consequences of
mind,
soundness of mind.
Unsoundness of
Become-
mind.
It is unsoundness
Become
mind.
they
voidable
cannot
marriage.
give
Remove the
valid consent.
hence it is the right answer for that question.
Yes, option B is the right answer, and all the remaining are correct. 19th question. Option that is the wrong statement, which is the right answer. Okay.
Yeah,
19th
wrong
question.
statement, right
Where
answer.
the wife? Yes, 19th question. Where the wife, on account of structural malformations of vagina, was not capable to have sexual intercourse, but she underwent surgical operation, as a result of which she became capable of having sexual intercourse. Therefore, it was held that she was not impotent, was decided in the case of option A, Charvanti versus Bhaura. Option B, Yes versus S. Option C, Ganeshji versus Astuben. Option D, Yam versus S.
Option A.
WRONG.
Ganesh.
Option B.
Option B, sir.
WRONG.
Option C. Ganesh.
RIGHT. Right answer.
Ganeshji versus Astuben. That is option C is the right answer. That means after undergoing surgical operation, it has become potent to carry the
Yeah,
children.
but
Sir.
we cannot say it's important.
21st question, in the legal language,
No,
the
20th
wife
question.
was senior. 20th question. The wife was senior to her husband by 7 years, but this fact was conceived at the time of marriage, since it was amount to fraud. Concealment of previous marriage will amount to fraud was decided in the case of option A, Anant versus Lajavati, option B, Somdat versus Rajkumar, option C, Sujit versus Harichand, option C, Balakrishna versus Lalita.
Option B.
Read full.
Samdut versus Rajkumar.
RIGHT.
Option B, Somdat versus Rajkumar. Is
Right
it
answer.
Samdat or Somdat? Somdat. Now,
21st question.
sir, here second statement is concealment of previous marriage. The
Yeah,
first
because
one
if
is
anything
7
would be
years
there,
older.
it should be brought to the notice. Otherwise, it is amount to fraud. Even
21st question.
previous marriages also. Next.
Even age also.
Yes. Age as well as conceiving that she is married earlier.
21st question. In the legal language, the term contract can be defined as an agreement that the law will enforce in some way. It is legally binding and must contain at least one promise. That is a commitment or offer by an offerer to and accepted by the offeree to do something in the future. It is dash rather than dash. Fill with appropriate words from the options or multiple choices. Option A, executory and executed. Option B, executed and executory. Option C, past and future. Option D, future and past.
Option A, executory and executed.
RIGHT.
Yes, option A is the right answer. Executory and executed. It is executory rather than executed. Now, 22nd question. The landmark cases in law of contract in India, case law. Welfare versus welfare.
No, let them give the answer.
We have already
Give
discussed
the
this.
landmark case law in law of contract. Only name of the case law. Enough.
Yes. Okay.
Same Balfour versus
Roll up.
Balfour.
Okay, next.
Balfour versus
Roll up.
Next.
Roll up,
Feldhaus
sir.
versus Bentley.
Carlyle versus Alex Bulk Company.
Feldhaus versus Bentley.
Lalman Shukla versus Gauri Shankar.
Lalman Shakla versus Gauri Dutt.
Next.
Mohiri Bibi versus.
Nobody is saying Mohir Bibi versus Dharmdas Ghosh.
That's Ghosh.
Next.
That is pertaining to minor.
Yes, next.
Dunlop Pneumatic
That-
Company
that
versus Selfridge Company.
That
Okay,
ginger
okay.
picture.
Next.
That is that.
Privity of contract. What is the AP case law? Privity of contract.
That is Dunlop.
No, I said that Dunlop is a privity of contract is a foreign case law. The similar case law in India.
Case.
AP case law.
Ginger
R
case.
versus
I say Indian case law, AP case law, similar to the Dunlop case law. Chinnaya versus Chinnamma versus Ramaya.
Avasram.
So now already almost hard. And Balfour versus Balfour is Balfour versus Balfour is invitation to contract. Wrong. social contract cannot be enforceable. Repeat.
Social contracts cannot be enforceable within
social
wife and
contract is
husband.
enforceable.
Okay, Lanman Shukla versus Gauridat.
This is regarding, I think, open contract. Communication offer must be communicated, I think.
Yes. It
Yes,
should be
already
known to the person before doing, but after he found the nephew, if you want to get the money, he said no. That is the Lanman versus Gauridat.
Because offer must
Okay, Carlin,
not
everybody
communicated.
knows. Tell me.
That influence
which
the
is
case.
I said
which is
principle.
guarantee to cure.
No. Intention to create the
General
legal
offer.
relationship. It is not a puff.
Yes.
Repeat.
Intention to
Not a
create a
puff.
legal relationship. It is not a puff.
Of course, everybody knows. Say the principle,
The fact.
including Sri Vidya. Because you are
Contract
very
with
anxious to give the
minor
answer,
to
no?
provide.
Yes.
Intention. There was no intention to enter into a legal obligation with.
Chinnaya versus Ramaya, just before I told you. Privity of contract.
Bearing similar names.
But here in this case law, what is that, no? The suit was filed by the old lady's sister. Here Chinnaya is the old lady's sister and Rama is the old lady's daughter. When a beneficial is there, can she be entitled to get the benefit? They say generally a party not to the contract cannot have a right to sue.
The third party cannot sue against the contract between two persons.
But because if she is a beneficial, the argument given by the Ramaya is that the state received by her is a gift and she has no contract with the Chinnaya, then she has no obligation to pay. The Supreme Court held that gift deed and the annuity agreement are both simultaneously agreements and both can be considered as one transaction of thus. So consideration has to be paid to Ramaya to Chinnaya. So privity of contracts is not applicable over here because she is a beneficiary. When she is a beneficiary, even though she is not a party, but she is the loser. Am I right?
Then the privity of contract is not
Fallacy.
applicable.
Fallacy. Okay, next question. 23rd question, read.
23rd question is, how much information by the accused will be admissible before the court of law under dash? The Indian Law of Evidence Act depends completely upon the nature of the fact discovered in relation to such information. Option A, Section 25, option B, Section 26, option C, Section 27, option D, Section 28.
Option B, section 26.
Option C,
Option C,
section 27.
27.
I
Right.
think option C is the right answer.
Read the feedback.
Section 27, option C is the right answer. Section 27 of the Indian Evidence Act 1872 that deals with how much of information received from accused may be proved is nothing but a proviso to Section 25 and 26 of the Act, as has been observed by the Supreme Court of India in the case of both Raz et Bodha and others versus State of Jammu and Kashmir 2002 case. 24th question. Which is the Parliament Act of case law? Option A, Navtej Singh Johar and others versus Union of India. Option B, State National Capital Territory of Delhi versus Navjot Sandhu. Option C, Santosh Anand Avadut H. Ghanshyam versus State. Option D, Naresh Agar Singh Shara Naria versus State of Gujarat.
Option A.
Option A.
WRONG.
Option C, sir. Santosh
WRONG.
Sidhu.
Option B. State of NCT
WRONG.
Delhi versus Navajot.
Naresh Agaresh. Agarshina.
D is the right answer.
D. Option D. Naria.
State NCT
Option
of Delhi
D is the
versus
right answer.
Navjot Sandhu. Feedback?
State NCT of Delhi versus Navjot Singh. Option B is the right answer. By interpreting the application of provision 63, 65, and 65, capital B of the Act 1872, the apex court in this case overruled its earlier decision made in the case of state NCT of Delhi versus Navjot Sandhu 2005, commonly known as the Parliament Attack case. The National Capital Territory of Delhi, NCT, is a special union territory of India jointly administered by the central government, the NCT elected government, and 3 municipal corporations. Here there is a subsidiary question, sir. In
Yes.
Delhi,
Yes.
the police department is governed by in NCT.
Okay.
Police department is governed by whether state or center.
Yeah, even even by, but generally when you say the police,
In
it's come under the state.
Center.
But
the
now
Because there is
center
lieutenant
is
governor,
in
no?
control of police department in NCT Delhi, sir.
okay, okay.
That is under the Home Department, 25th
Okay.
person.
Okay.
The Supreme Court has imposed a 1-year sentence on cricketer turned politician Navjot Singh Sidhu in a 1988 option A, hurting aged person, option B, voluntarily causing hurt, option C, road rage case, option D, abuse of process.
Option B, sir.
Option A, hurting aged person.
You can
WRONG.
say this answer, sir.
Option B, voluntary causing
Option
out.
The right
Option
answer
C is the
is
right answer, sir.
C, road rage
Option C,
case.
road. When there was some traffic problem, he got down. Navjot Singh Sidhu got down and hit with his cricket bat, and that person died there.
Even though it is a hurting aged person, even though it is a voluntary causing hurt, even though it is the abuse of process.
That is not in road. I think it is in his building parking area. Security guard is there, old aged security guard. Then he hurted that aged person with only one time, one bit. He died already.
Okay.
That's why that is hurting aged person.
Road rage case, that is called.
Maybe.
Next.
Okay.
Now, 26th question. With technology overpowering human intelligence, section 65, chapter B of the Indian Evidence Act 1872, that concerns the admissibility of electronic evidence and was inserted in the state statute by means of option A, option A, Indian Evidence Amendment Act 1999, option B, Indian Evidence Amendment Act 2000, option C, Indian Evidence Amendment Act 2001, option D, Indian Evidence Amendment Act 2002.
Option D, Indian Evidence Act Amendment Act 2002.
Option D is the right answer, sir.
Is it? Yes. It is. It is.
Came.
Are you hearing me?
Okay. 2000. Option
Sharad
B
Babu.
or D?
Sharad Babu. Because it cannot be
I agree with
recorded.
the participant.
Sharad Babu, listen
I
to
agree
me.
with the
It is not recorded. Read the 27th question again.
The case of dash holds immense importance in today's technology-driven world as the Supreme Court in this noteworthy case decided on the admissibility of electronic evidence in a court of the law taking into account Section 65 capital B of the Indian Evidence Act 1872. Option A, Arjun Panditrao Khatkar versus Kailash Krishnarao Garayantai and others. Option B, Anwar PV versus PK Bashir and others. Option C, Dr. Sunil Clifford Daniel versus the state of Punjab. Option D, Bhimsla Subarna Pawar versus state of Maharashtra.
Option B, Anwar P.
Option
versus
A, Arjun
Yeah,
Pandit
option
Rao.
A. Option A, Arjun Panditra.
Option A is wrong.
Option B, Anwar P. versus PK Bashir and ORS.
Option B is RIGHT, right.
Anwar PV versus BK Bashir and others. Option B is the right answer. Now, 20th question. Dash power of court to engage experts or dealt in specific relief act. Option A, Section 14. Option B, Section 14A. Option C, Section 14, capital B. Option D, Section 15.
Option B,
Option B,
14A.
14A.
Option B, 14.
Option B is the right answer.
Section 14A is the right answer.
Capital A. Yes, next 29th question.
Match the part A with explanation in part B. Part A, section 37, 1, that is in the second is section 39, third is section 40, fourth is section 41. And on part B, the options are option A, mandatory injunction, option B, temporary and perpetual injunction, C is injunction when refused, D, damage in lieu or in addition to injunction. Option A, 1B, 2C, 3D, 4A. Option B, 1C, 2B, 3A, 4D. Option C, 1B, 2A, 3D, 4C. Option D, 1A, 2D, 3C, 4B.
Option C.
Option C.
Option
Right.
C.
RIGHT, right.
So C is the right answer. 1B, 2A, 3D, 4C. Section 37, temporary and perpetual injunction. Section 39, mandatory injunction. Section 40, damage in lieu of or in addition to injunction. Section 41, injunction when refused. In lieu of means instead of.
Yes.
Now, 30th question. In the case dash, it was held by the Honorable Court that the Limitation Act applies to courts and not to quasi-judicial authorities. Option A, Pawan Kumar Agarwal versus State of West Bengal and another. Option B, Maharana Pratap Charitable Trust versus State of Haryana, another. Option C, DLF Limited and others versus State of Haryana and others. Option C, Papat Bahiru Govardhane versus Land Acquisition Officer.
Option A, Pawan Kumar Agarwal versus State of West Bengal and another.
WRONG.
I think option C
Option
is the right
C,
answer.
sir. Option C.
DLF LTD.
WRONG.
Option D, Papat B.
Popat Bahiru Govardhane versus Land Acquisition Officers. They said it is not applicable to the quasi-judicial authorities. It is applicable only to the Court Proceedings Limitation Act. Feedback.
Option D is the right answer.
Okay, what is DLF?
Govardhane versus.
What is DLF?
That is
See, in the Tata,
Delhi.
Tata, when you go to the Central University, there is a big building is there, DLF. Earlier, Pegasus system was hired that building. Of course, many IT company hired that building.
This,
DLF.
I think this loans towards housing.
See, this is DLF means Delhi Land and Finance. Delhi Land and Finance. DLF stands for the Delhi Land.
Finance stands for Delhi Land and Finance. Delhi Land and Finance is one of the largest commercial real estate developer in India. The company was founded by Chaudhary Raghavendra Singh in 1946. The headquarters of DLF is in New Delhi, India.
So these are the cases, the multiple choice questions, I coined it because I told you the problem is when you read this and we want to feedback, no, which one is the right answer, which one is the wrong answer. For instance, I read this one because you read 30 questions.
If you observe the model paper, sir, there is a type of question. Which of the following is a mismatch? And out of 4 options, one will be a mismatch, and we have to identify it.
Yeah, because now the
Just like
For
this,
matching also, we need to know the 4 options. For mismatching also, we need to know the 4 options. So they are simply saying 100 questions, but there is 400 questions. We are writing for exam prelims for 400 questions. If we know the 400, then only we can shoot
how
100
many
questions.
questions are there in the screening test?
See,
100 questions only, but
100
much
questions.
they are covering in one question.
I don't know what you are discussing. I want to say my problem and you are discussing your own way.
Okay, carry on.
My problem is, see, according to section 2B of the CRPC 1973, charge includes. Suppose if you give the right answer, whether it's right or wrong, again I have to scroll down. Again I have to scroll down to see. Is it not a consuming? So one will scroll down if you
I am
have
having key
answer.
with me, sir. Please carry
If you know the answer, you have to give the answer. But how could you be a participant? Are you understood my point?
Yes, sir. Yes, sir.
Sharath, you go to the key. I already posted you. You go to the key and be ready with the key. Then I read it and everybody participate it. And you confirm whether it is right or wrong. Are you following me?
Yes, sir.
And if you want the key, see the last it is the key is there. You take the screenshot. I already posted you the key.
Okay, but
Yes, now you take the screenshot if you want. This is the key. You take the 2 screenshot because this is one screenshot and this is another screenshot. Ari, because I already posted, it is with you. Did you get my point?
okay, sir.
See, now I can read it.
Carry on.
Everybody could participate and you give the answer for that one. Okay. According to section 2B of the CRPC, shall I proceed?
Proceed, sir. Proceed.
Shall I proceed? Because if I heard the sound, it is an obstruction to me. My tongue is tied, my legs are fettered, my hands are handcuffed. Shall I proceed?
Yes, sir.
Yes, sir.
Very good. According to section 2B of the CPC 1973, charge includes A. Heading of the charge. B option. Any head of charges when the charge contains head. C. Any head of the charge when the charge contains more heads than one. And D. All of the above.
Option
Option
C.
C. Option C.
Charat Babu.
Option D. All of the above.
Sharat
Option
Babu,
D
you
is
have
the
to
correct
confirm.
Charge.
Any head of the charge when the charge contains more head
Sharat
than one.
Babu, you have to confirm. That is the
Option
reason.
C is the correct answer, sir.
Option
Hello?
C.
Sharat Babu, you have to confirm. First question answer.
First question, that is any head of charge when the charge contains more heads than one. Option C is the right answer.
First you say C option, then you read. Is it clear?
Some audio disturbance is there, sir.
Okay, no, it is very clear to me. And for the other people also, it's very clear to me. Okay, now the second question. As per the amendment 2008 of the CRPC, the new definition that was inserted under the section 2 WA clause is A, audio, video, electronic means, B, option victim, C, option victims compensation, D, option victim compensation scheme. Shoot.
Option B.
Option B, victim.
Option D. D victim.
Confirm, Sharad Babu.
What as per the agreement, second question, sir.
Second question.
Option B is the right answer, sir. Victim.
Victim is the right answer. Okay, next. Third question. The examination of the witnesses by the adverse party is A, examination in chief, B, cross-examination, C option, re-examination, D option, oral examination.
Option
sir,
B,
cross-examination.
examination.
Option B is the right answer, sir. Cross-examination.
Cross-examination.
Like the fourth
By
question.
adverse party means by the opposite party.
Shall I proceed?
Yes, sir.
Fourth question.
Yes, sir. Proceed.
Facts not otherwise relevant or relevant.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।